Good morning and welcome to this webinar brought to you by the Edmonton Construction Association on the new CCDC-2 Standard Stipulated Price Contract form, known as CCDC-2 2020. My name is Michael Atkinson. I'm the immediate past president of the Canadian Construction Association, a position I held for some 23 years. I'm a lawyer and a former secretary of the Canadian Construction Documents Committee from 1983 to 1993. And contrary to the rumor you may have heard, the documents were not on stone tablets at that time, but yes, I was around when the current version of 2 really took it first shape back in the early 1980s. And I think it's important to remember, well, first of all, if questions, you can submit them by the chat option or the Q&A option. Taylor is going to be monitoring them, and after my presentation, that's when I'll take up the questions. I hope to go about 45 minutes, and hopefully it'll be more than enough time for your questions. I think it's important to remember before we get into the guts of what has changed in Document 2 is what is Document 2. Document 2 basically is the standard contract form that addresses the stipulated price or fixed price or lump sum contract pricing method, or the design, bid, build, contracting, or project delivery method. And it's also CCDC's flagship document. It essentially is the document on which the CCDC bases the other standard forms of contract that it creates that addresses other pricing methods and other delivery methods. For example, CCDC publishes a design build contracts, construction management contracts, a unit price or civil works contract, cost plus a fee contract, but CCDC-2 really is the flagship. So the changes we're going to talk about today eventually are going to find their way into those other standard forms to the extent that they're applicable to the pricing method or the delivery method that's being used in those circumstances. So what I'm going to do firstly is go through all of the main changes I want to talk about very quickly in a summary fashion, and then we'll get into detail on some of these. And I understand the Edmonton Construction Association is going to be providing you with this PowerPoint after, so you don't need to worry about taking notes or anything. So there's 4 major changes in this new document. Perhaps the most important is the introduction of a new contractor project milestone called Ready-for-Takeover. It has as one of its prerequisites the attainment of substantial performance of the work. And this is an extremely important new concept that has been introduced to the document that we'll get into in a moment. And why it is so important, while it doesn't replace substantial performance of the work, substantial performance of the work still is an important milestone throughout the contract. It does take over from substantial performance of the work for important timing or triggering events throughout the contract. The second major change is the document now allows for the early occupancy of the work or a portion thereof by the owner with the contractor's agreement, and that's an important condition. And we'll get into that in a couple of minutes. The third major change is that some of the provisions that formerly were in the general conditions and in the definitions have been moved to the specifications. And in fact, the CCDC has published with the new CCDC-2 a new master specification for Division 1, the general requirements. And that's where these items would now be addressed in Division 1. The fourth major change are changes to acknowledge the potential existence of new mandatory payment and adjudication legislation in the particular province of the place of the work. And this is extremely important here in Alberta because you do have this legislation coming. The latest I've read is that it could be in effect as early as July. So Ontario's already got this particular legislation in play. Alberta's legislation is extremely similar to that's now in effect in Ontario. And the province of Nova Scotia has also passed very similar legislation, although it hasn't gone into effect yet. So the CCDC-2 now is trying to not only acknowledge the fact that this new legislation is in place, which by the way overrides contracts. You cannot contract out of this new legislation. And we'll see how the document has responded to that. Okay, there are a number of specific changes I would like to talk about throughout the document. some of them are somewhat editorial, some of them are somewhat perhaps obvious, but important to note in any event. Number one, in the article A6, the document talks about the appropriate methods for communication between the parties, including the delivery of notices in writing. And that's extremely important because the requirement to submit a notice in writing to the other party will also trigger or be a condition precedent to the party having the right to do something under the contract. For example, delay provision. If the contractor feels that his prosecution of the work, his construction has been delayed by the owner or somebody for whom the owner is responsible, they must first provide a notice in writing to the owner in order to have the ability to impact contract time or contract price. So very important what the methods and modes are for written communication, such as notices in writing. Well, one of the changes, it no longer accepts facsimile or by communications by fax as an acceptable method. So you probably feel, well, that's appropriate. Fax machines aren't being used by many, but you get on the odd job or situation where fax is still the method or means by which the parties are going to be communicating. You got to address that now in the contract. Or indeed, if there are other methods of communication not conceived or perceived by the document, Article A6 is where you would address that. Number two, there's some new definitions in the contract, and there are some revised definitions, and we'll look at those. Three, there's been a clarification to the hierarchy of the contract documents. Now, the contract documents are basically the general conditions, the specifications, the drawings, schedules, pretty well anything that the parties wish to have part of the contract. And there is a provision in the document that deals with, well, which one takes precedent where there's a conflict between the two. Well, the committee's made some, what I would consider editorial changes to clarify that hierarchy. But perhaps more important, there have also been some changes to the document that talk about what the purpose is behind the contractor being required to review the contract documents. And we'll get into that. Number four, there's been modifications to the role of the consultant. Now, the consultant's not a party to this contract. So anytime this contract speaks about the consultant doing all these weird and wonderful things, that's, of course, it's not binding whatsoever on the consultants. The consultant's contractual obligations flow from their agreement with the client, with the owner, not from that contract. But there have been some changes to the description of what the intended role of the consultant is under this contract. Another specific change is changes to the description of what are eligible reimbursable expenses for change directives to provide more clarity. And change directives, of course, are a situation in which parties have agreed that there's a change in the work but can't agree on how it impacts contract price. This allows the work to proceed, but on a cost plus or reimbursable cost basis. There have been some changes to the delay provisions, and one change in particular, which is extremely important for contractors, especially during these pandemic times, and we'll talk about that. Continuing, the other 6 changes or so that I would like to talk about are changes clarifying the content of default notices and the role of the consultant responding to those notices. And this is a situation where the owner feels the contractor's in default for neglecting to prosecute the work or for being in breach of contract. The notice of this allegation that goes to the consultant from the owner, the particulars of that notice now are prescribed in the new CCDC-2 document, and the manner in which the consultant responds to that notice or allegation, if you will, also have changed, and we'll talk about that. The insurance requirements have changed. Now, the insurance requirements, the minimum insurance required on a given project using CCDC-2, those aren't contained in CCDC-2 itself, but are in the guide document CCDC-41, which spells out the actual minimum insurance limits. Those limits have been increased. We'll talk about that. But more importantly, some of the timing or duration of the policies have changed as a result of the introduction of the new milestone Ready-for-Takeover. Likewise, the indemnity and waiver of claim provisions in CCDC-2 have changed because the new trigger date now becomes this new milestone date for Ready-for-Takeover as opposed to substantial performance of the work. There's been some changes to the administration, if you will, of cash allowances. there's a brand new provision dealing with construction safety, which is extremely interesting and enlightening to some extent. And there's been a change to the provision in the contract that deals with how to treat new taxes or duties or changes in taxes and duties that occur after the bid closing time. What happens to the contract price, where that increases or decreases the cost of the work, and we'll talk about that. Okay, the first one, probably the most interesting and probably the most impactful, if you will, new concept in the contract is the introduction of Ready-for-Takeover. Now, Ready-for-Takeover is defined in the new contract as being achieved when all of these 8 conditions that you see on this slide are in fact met. And you'll see that one of them is the consultant has certified substantial performance of the work. So the implication here is that Ready-for-Takeover occurs sometime on or after substantial performance of the work. 2, evidence of compliance with the requirements for occupancy or an occupancy permit has been obtained. 3, final cleaning and waste removal has occurred. 4, O&M manuals required for immediate O&M have been delivered to the owner. A copy of the as-built drawings completed to date is available. Startup testing required for meeting occupancy done. The owner's ability to secure access to the work has been provided, and the contractor has arranged for demonstration and training for the owner's personnel. So all of these prerequisites have to have been met before Ready-for-Takeover has been attained on the contract. Now, why the need for Ready-for-Takeover? Why did the committee do this? Why has it introduced this new milestone? Well, the only real milestone in the contract was substantial performance of the work. And this is a concept that was borrowed from builder's lien legislation. Substantial performance of the work really deals with liens and release of holdback. It wasn't intended to deal with actual contract completion milestones, if you will. And what was happening was the committee found that the CCDC-2 documents were being routinely amended through supplementary conditions by owners who began to attach a number of other requirements that had more to do with the performance of the contract or the degree of completion. They were requiring such things as occupancy permits, or were requiring O&M manuals or as-built, et cetera, et cetera. And what this was doing was, in essence, was delaying the attainment of substantial performance of work under the contract, and was obviously going to then delay the release of holdback in many situations. And so as a result of that, the committee decided that it was apropos to identify a new concept, a new milestone date in the contract that would more appropriately address those concerns that owners had raised regarding completion dates. So if you look at this slide now, this is sort of a summary of what this new concept, Ready-for-Takeover, is and what it is not. It is not a substitute for substantial performance of the work. I have said that one of the prerequisites for attaining Ready-for-Takeover is certification of substantial performance of the work. So it's one of 7 or 8 criteria in order to achieve Ready-for-Takeover. So Ready-for-Takeover is not substantial performance of the work. It's not a milestone that triggers holdback release. That continues to be substantial performance of the work as laid out in the applicable lien legislation. It is not certified by the consultants. As we will see, the new contract, and the new CCDC-2, calls upon the consultant to verify and confirm the fact that Ready-for-Takeover has been achieved, but does not certify. The consultant continues to certify substantial performance of the work, but they do not certify Ready-for-Takeover. They verify or confirm. So that's what Ready-for-Takeover is not. What is Ready-for-Takeover? Well, as I said, it's a new additional milestone in the contract. It's a milestone that includes the attainment of substantial performance of the work, among other prerequisites. It's verified and confirmed by the consultant, as I mentioned, and the new contract time milestone date. This is important. In the Articles of Agreement of CCDC-2, the parties set out the contract time, and essentially that is the date from which the contractor is to commence the work and the date upon which the contractor is to, under the old CCDC-2, it was achieve substantial performance of the work. Now that is achieve ready for takeover. So arguably, since ready for takeover is a point in time that normally would occur after substantial performance of the work, one of the immediate impacts of this new concept, ready for takeover, is that the contract time has been extended under CCDC-2. It also, ready for takeover, is now the new general warranty start date. You know, the 12-month or 1-year general warranty that CCDC-2 has. Under the old document, it commenced on the date of substantial performance of the work. It now does not commence until the date for ready for takeover. So again, one could make the argument that the warranty period, the standard general 12-month or 1-year warranty period, has been extended. Ready for takeover is the new duration for required insurance coverages. Some of the required insurance coverages under CCDC-2 say that the insurance is to be in place so many days following the date of substantial performance of the work. That now has changed to read so many days following the date for ready for takeover. So again, one could make the argument the duration of some of the required insurance coverages under the document has been extended. Now, it's important to understand that whereas ready for takeover has replaced substantial performance of the work in each of those things I've talked about, it has not replaced substantial performance of the work in the contract. For the reasons I stated earlier, substantial performance of the work still is the thing that you go to with respect to holdback release, liens, etc. That remains in place, and indeed, that's what the legislation would require in any event. Ready for takeover is also the new trigger date for the mutual waivers and indemnity obligations, which we will see in a minute. Basically, that gives you a summary of what this new milestone is, and perhaps more importantly, what it is not. Now, the verification process for ready for takeover, as mentioned earlier, the consultant verifies and confirms that ready for takeover has been achieved and does not certify. When the contractor considers that the work is ready for takeover, the contractor delivers a comprehensive list of items to be completed together with an application for ready for takeover for review by the consultant. The new contract goes on to say that the consultant will then review the work to verify the validity of the application, and no later than 10 calendar days after receipt of the application, advise that the consultant agrees or does not agree. And there is a similar statement that was in the previous version of document 2 with respect to substantial performance of the work that states that ready for takeover shall not be delayed for conditions reasonably beyond the contractor, which makes a lot of sense. So as you can see from these provisions, then the role of the consultant is to essentially determine whether or not ready for takeover has been achieved using those 8 prerequisites that were outlined on the previous slide. Okay, one of the other major changes to the document is a new provision that allows the owner to take early occupancy of a portion of the work of the entire work, only as agreed by the contractor. Now, some of you might say, well, why do you need the provision then? Because if both parties agree, both parties to a contract agree, they can pretty well do anything they want, right? And you could essentially do this under the previous version of CCDC-2 if the contractor and owner both agreed. You could have early occupancy. What this new provision does is it provides some discipline, puts some rules in place with respect to what happens in this situation. For example, the contract makes it very clear that the owner must have the approval of the authorities having jurisdiction in order for early occupancy to take place. It also goes on to say that where the owner takes early occupancy of a portion or a part, it shall have been deemed to have been taken over by the owner. So care, custody, or control of that portion of the work goes from the contractor to the owner in such circumstances. The contractor ceases to be liable, if you will, for the care of that part. And it goes on to say that the warranty for that portion occupied shall start. Now, of course, that begs the question, if it's a commercial office building and the owner intends only to take occupancy of one floor and you've got to turn the mechanical system on for the entire building, does that mean that the warranty for the mechanical system commences at that point? Those types of questions or situations, depending on the facts, would have come up in any event. But at least now what this provision does is it recognizes the fact that the document was often being amended or revised to allow for early occupancy, and is now trying to put some discipline, some rules in place as a result of that. Another statement in the new contract is that if early occupancy is the entire work, then it shall be deemed to have been to have achieved ready for takeover. So if the owner occupies on an early basis the entire work, then ready for takeover is deemed to have been achieved with no need to be verified or confirmed by the consultant in those circumstances. Okay, some of the provisions in the old CCDC-2, in the general conditions and in the definitions, have been relocated to the new Master Specification Division 01, or the specifications. Another way of looking at this was that the committee had found that these particular topics were being dealt with in the specifications. And in fact, when they were being dealt in the specifications, some of the specifiers forgot that they were also being dealt with in the general conditions, forgot to amend the general conditions, and it created a conflict between contract documents. So to try and avoid the necessity of having supplementary conditions dealing with those changes, or trying to avoid conflicts per se, the committee has decided, let's let the specifications deal with the subject matter rather than the contract. And in our new master specification for Division 01, we'll put the wording in there so that the parties can address these matters. So the things that have been removed or relocated, if you will, the definition of the word provide. How many sets of contract documents were to be made available at the site? Portions of the shop drawing provisions dealing with more of the mechanics rather than the rights or the responsibilities. Use of the work, cutting and remedial, cleanup, and contract security. You know, whether you're going to need a bond or cash or whatever for performance bond or an L&M bond or security, that's a question that has to be dealt with much earlier than when the contract was signed. So that one makes a lot of sense. So the shop drawing provisions, some of them remain, but the biggest difference here is the subject matter that dealt more with administrative aspects. That's been moved now to the specifications. What remains in the contract, however, are the provisions that require the contractor to review the shop drawings, et cetera, things that deal with responsibilities and the role of the parties in those circumstances. Same with cutting and remedial work. Provisions do remain, but what's more of an administrative nature, that has been moved. Okay, another major change is the fact that the new contract recognizes the fact that there may be this new mandatory payment and or adjudication legislation in play, which overrides the contract. You cannot contract out of this legislation. But it goes a little further than that, and we'll see. And on this slide, that, for example, the new document has a definition of payment legislation, which essentially is the kind of legislation that you've passed in Alberta, and we'll see shortly. It makes a statement that the payment process in CCDC-2 2020 shall be in compliance with applicable payment legislation. Well, that's a bit redundant since the legislation applies in any event, no matter what your contract says. However, what's more important is that revisions have been made to the payment process and terms in CCDC-2 that essentially adopt those that are in this new legislation that's in Ontario, proposed in Alberta and Nova Scotia. So even if you are on a project in a province in which this legislation doesn't exist, you're going to find that the payment process and payment terms in CCDC-2 are more akin to, parallel, very close, very similar to what's in such legislation. Also, there's now a statement in the contract that says that a provision has been added that says that nothing in CCDC-2 shall affect the rights of parties to resolve any dispute by adjudication. And adjudication is this relatively new alternate dispute resolution method that's being introduced. Now, it's an interim resolution process. the decision of the adjudicator is only good really till the end of the project or when the parties appeal it through arbitration or litigation. But it's an interim decision or an interim resolution, if you will, only. So as we'll see, it doesn't interfere at all with the stepped dispute resolution process that CCDC lays out, and we'll talk about that. Okay, now I mentioned that not only do these new changes to document 2 recognize you may have this legislation, they've actually changed the payment process and the payment terms in CCDC-2 to be in line with, parallel those that are in the legislation. For example, applications for payment now must be submitted monthly to both the consultant and the owner simultaneously. Now, what's important about that are 2 statements. They must be submitted monthly. Previously, the old CCDC-2 simply said maybe submitted monthly. Now must be. In addition, it's to be the monthly progress applications, payment applications are to be given to the consultant and the owner. Now, why is that? Well, under the payment legislation, the owner has 28 days to pay the contractor from the date that they receive the proper notice, which is a term defined in the legislation, or must give reasons why they are not going to pay or pay that amount within 14 days. The clock doesn't start in either case until the owner receives the monthly application. So right away, especially for you in Alberta, if you're not already on your projects, all of your projects, not just the ones in which CCDC-2 are in play, submitting your monthly applications to both the consultant and the owner start now. Because under your new act, the 28 days, the clock doesn't start ticking until the owner is in receipt of the application. Very important point. The new provisions in CCDC-2 also require that all monthly applications have to be accompanied by evidence of compliance with workers' compensation legislation. Prior to that, you only had to show it, provide this evidence with, I think, your first draw and with your application for substantial performance of work. Now it's with every monthly draw. Similarly, there's also a statement in the new CCDC-2 that states that you must provide a stat dec form in the form of a CCDC-9A with your second and subsequent monthly application payments. Previously, I think that was only required again at the time of substantial performance of work. Now it's required with all but your first monthly application for obvious reasons. There's another change in the payment process in CCDC-2 that says if the consultant certifies a different amount or rejects the application, the owner, not the consultant, it used to say the consultant will promptly issue. Now it says the owner will promptly issue a written notice to the contractor giving reasons. Why? Well, that's because the owner now is in receipt of the application, and the legislation requires the owner to take action within a 14-day period if they object to the amount being applied for in the proper notice received by the contractor. So those changes are to reflect the changes coming in the new legislation. Similarly, the payment terms have been changed in CCDC-2. In the old version, basically the owner had 20 days from the date of the end of the payment period, which is usually the date of the end of the previous month, or 20 days from the receipt of the application, whichever is later. Now it's 28 days from the receipt of the application. So even if you are in a province in which there is no mandatory payment legislation applying, the new CCDC-2 says the owner has 28 days from the receipt of the application for payment to pay. Similarly, the contract now has been changed to say that the holdback's now not due and payable until 10 working days following expiration of the holdback period. Previously, the CCDC-2 said it was the first calendar day following the expiry of the holdback period. So I think in Alberta, that's 30 days right now, going to 60, by the way, under new legislation. So it would be the 31st or the 61st day under the old document. Now it's some 9 days later or so under this contract. And as I mentioned earlier, the fact that adjudication is available to the parties by legislation is still fine, and CCDC-2 says that it recognizes adjudication, and nothing in the contracts is intended to take the ability of the parties to use adjudication away. But remember, again, it's only an interim dispute resolution process. So if the decision of the adjudicator is disputed by one of the parties, then the CCDC resolution method for disputes then takes over, and you go to the contract to determine, well, mediation, arbitration, litigation, perhaps. So that hasn't been impacted. Okay, I mentioned notices in writing, so I'm going to skip over that. That seems pretty clear. New definitions have been introduced. Well, other contractors. Now, this was one that was implied in the last legislation. Other contractors, simply somebody that's engaged by the owner to work on the same site. Payment legislation is a new definition, and for obvious reasons that we mentioned. It's defined. And ready for takeover. The introduction of this new milestone or new concept, it's defined and it's a new definition in the document. There's some changes to the definitions. The definition is no longer numbered. Not sure that makes a big deal. As I mentioned earlier, the definition of the word provide has been relocated to Division 1, but the definition of substantial forms of the work has been changed. In the old version, it basically said that the definition of substantial forms of the work is whatever the applicable lien legislation said it was, and then went on to say if such legislation did not exist or did not have such a definition, then it shall have been reached when the work is ready for use or is being used for the purpose intended and so served by the consultant. That language is all gone now. So the only definition of substantial performance of the work recognized by the new CCDC-2 is the definition of applicable lien legislation, the Builders Lien Act in Alberta. Well, what happens if you're working on a project to which the lien legislation doesn't apply, such as on federal lands, an airport, for example? Well, you won't have a definition of substantial forms of the work, and the parties will have to address that in the document because there is no definition of substantial forms of the work in that situation. And similarly, if there is no definition in the applicable legislation, as is the case in the province of Quebec, for example. So it's an issue to be aware of. Contract documents. I mentioned there were two changes here. One is to try and clarify the hierarchy of contract documents, and that's the situation where there's a conflict that exists between them. You can see what those changes are on the slide, the underlined words that have been added there. Now, it's important to understand that this clause only comes into play when there's an actual conflict between the contract documents. So if something is shown in the specifications and not the drawings, is that a conflict? I would suggest it may not be, particularly now that a new provision has been put in the contract that essentially says that the contract documents are complementary, and what is required by one shall be binding as if required by all. So not in the drawings, but in the specs, it's in the drawings as well. No conflict. So it's an important point to remember that there has to be a conflict before you go to this list. Okay, what is perhaps more important about the changes here is that there's been some express wording changes dealing with the review of the contract documents by the contractor. It now states the contractor shall review the contract documents for the purposes of facilitating coordination and execution of the work by the contractor. Goes on to say the contractor is not responsible for errors, omissions, or inconsistencies in the contract documents. So what this says is essentially the purpose behind the contractor's review of the contract documents is to facilitate her coordination and execution of the work by the contractor, not to find mistakes. The purpose of the contractor's review is not to find errors, omissions, or inaccuracies. If they do find an error, omission, or inaccuracy, yes, they are still bound by the contract. You have to bring that to the attention of the consultant and the owner. But the purpose behind this review is not to discover them. There have been many supplementary conditions used to change the language here in CCDC-2 in the old versions, that some of them pretty foreboding. I have seen some where essentially basically say the contractor should review the contract documents, and if they miss anything, if they don't discover an error or inaccuracy that they should have discovered, then they wear it. No extra. In my mind, that almost changes the document to a design assist or design build document rather than design bid build document. But the CCDC has certainly clarified what is the intent behind that role. Now, I mentioned that the description of the role of the consultant in the document has also changed, and this is important, but one must remember that the consultant is not a party to this contract, so anything you read in the contract doesn't bound the consultant whatsoever. But it does change the aspect of the role under this contract. When responding, well, first of all, consultants are stated to make determinations in some places in the old version of the document. That's been changed to findings, except when it comes to certification. Now, I have not found any difference between a finding and a determination, but I suspect that these changes were made to make the wording in CCDC-2 more consistent with the wording that's in client architect, client engineer agreements. I mentioned earlier that when the owner alleges that the contractor is in breach of the contract, default or non-performance, if you will, the owner's notice has to contain more particulars. Well, so does the consultant's response now. If the consultant agrees that the contractor is in default, the consultant now in their response must provide the details of the neglect. Previously, all they had to do was say, yeah, I think sufficient evidence exists. Yeah, that's okay. No, they now have to detail exactly what that is. Some of the consultant's role, as stated in the old document, has been deleted. One of them is that their obligation to inform the owner when they receive a monthly application. Well, they obviously don't have to inform the owner anymore because the owner now must receive a copy or have been served, if you will, with each of the monthly applications now directly. There's also a statement in the old document that stated the consultant will not be responsible for acts or omissions of the contractor. That's been deleted, probably been deleted because it had no effect anyway, because the consultant is not a party to the agreement. And what's been added is a statement that the consultant, part of their duties under this contract is to verify ready for takeover has been attained. Reimbursable cost for change directives. Some of this wording has been clarified to make it clear what's an acceptable eligible cost for reimbursement in these circumstances. It essentially limits all eligible costs to direct costs. I'm not going to go into the details of what's changed here. That information is on the slides, which you will be getting. Suffice to say that they've made some changes to this wording to try and clarify what's a legitimate or eligible reimbursable cost in the circumstances where you're operating under a change directive. And that's, again, a situation where the parties agree there's been a change in the work, can't agree on its impact on contract price, and allows the work to proceed on a reimbursable cost basis. There's been a very important change made to the one of the delay provisions in CCDC-2, and this is especially important for contractors and especially important given these pandemic times. The wording that has been added is the bolded and underlined wording here. And this is a situation where the contractor has been delayed in performance of the work by a stop work order issued by a court or other public authority, and providing that such order was not issued as the result or an act of failure of the contractor, resulting in the failure of the contractor to attain ready for takeover by the stipulated date in the contract, then the contract time bill shall be extended for reasonable time, and then the contractor shall be reimbursed by the owner for reasonable costs incurred by the blah, blah, blah. Well, you see right away that if the delay does not result in the failure of the contractor to attain ready for takeover, this provision can't be relied upon. So that begs the question, what happens if I, as a contractor, have found a way to do this work some 10 days prior to the date set up for ready for takeover? Hey, that's why I was low on the competitive bid. I figured out an easier, quicker way to do it. And I'm delayed for 7 days. The project is shut down for health, for other reasons, beyond the control of the contractor, through no fault of the contractor. And I can still achieve the set out date for ready for takeover in the contract. But I've been delayed 7 days. I got additional costs, et cetera, et cetera. I can no longer rely on this provision the way it's worded now. So an important point for contractors to look at. Now, we're going to talk right at the end about what to do in those circumstances. And if you do have COVID-related claims, what are some of the other provisions you can rely on? Okay, I mentioned the default by contractor, the situation that the owner now has to have more particulars in their notice alleging that the contractor is in default. They basically have to now make reference to the applicable provisions of the contract that they feel the contractor is in default of, et cetera, et cetera, et cetera. They can no longer just issue a general or broad statement saying that they believe the contractor to be in default. The insurance provisions have changed, both the limits and some of the important key trigger dates. 41 is where CCDC 41 is where the actual limits are prescribed. And essentially what's happened is for general liability, auto and man, etc., minimum limits have been increased to 10 million from 5. And the committee has introduced new insurance requirements for unmanned aerial vehicles, read drones, and for pollution with prescribed minimum limits of $5 million. And as I mentioned, the duration of some of these coverages, like property insurance, have now been extended in the sense that they now must run 10 days, not from substantial performance of work, but 10 days from ready for takeover. Similarly, the new trigger date for the mutual indemnity obligations, some of the exceptions and the waiver obligations as well, that trigger date is now ready for takeover rather than substantial performance of work. Basically what this means is wherever you saw the phrase substantial performance of work in the old indemnity or waiver provisions, that's now been replaced with ready for takeover. Cash allowance provisions have been changed. They've been revised to permit the consultant to use unexpended amounts from one allowance to cover any shortfall in a particular cash allowance. It seems rather reasonable. It's more administrative than substance. Now, here's a new provision that's been introduced dealing with construction safety. And what this attempts to do is, you know, the liability, if you will, for safety at the workplace, that's prescribed by the legislation. You can't contract that legislation. Occupational Health and Safety Act essentially lays that out. But what this provision does is it tries to outline what's the responsibility of the parties vis-a-vis construction safety. So it's an attempt to, yeah, there's the liability, but we want to spell out who's responsible for doing what when it comes to construction safety at the site or the place of the work, especially in circumstances where, for example, the owners using owner forces or have engaged other prime contractors to work on the contract. Another provision that's been amended is the provision dealing with what happens if taxes or duties change after the bid closing time that impact the contract price, either up or down. This change has been prompted by essentially a legal opinion that had stated that it only worked if the taxes and duties were in place at the time of the bidding. In other words, for example, if drywall was going to be used on the contract and after closing for bids, a tariff or duty was introduced on the drywall that obviously would impact the contract price, you could not look to this provision because the provision said that any increase or decrease in the cost of the contract due to changes in such included taxes and duties. And that reference to such included taxes and duties referred to taxes and duties in place at the time of the bid closing. So if it's a new duty or a new tax that wasn't in place at the time of bidding, the argument was this provision would not respond in those circumstances. So the committee has amended this by taking out the word such included, because the intent of this provision was that it would cover fluctuations in contract price due to the introduction of unforeseen new taxes or changes to taxes or duties, both ways, by the way, in those circumstances. And indeed, owners in some cases have looked for credits under this provision, particularly when the GST was introduced back in the early 90s, when the old federal sales tax, the manufacturer's tax, went away. The cost of acquiring materials that were subject to those taxes, the cost of those materials went down, and owners were looking for credits under this provision when the GST replaced it. So that's important. Okay, my last comment is on the, someone might be saying, where's the new COVID-19 or pandemic clauses? How come we haven't seen that? Well, First of all, this being a national document that applies right across the country and a document that they hopefully will not have to change every year, otherwise it ceases to be a standard one, the committee felt that their provisions existing in the document were broad enough, sufficient enough to deal delays or impacts on cost or contract time as a result of any pandemic or any shutdown in these circumstances. And the three provisions that are often used and are being used for delay claims, for example, under the current pandemic are 6.5.2, which I just mentioned, and subject to my earlier comments, that one only comes into play now if you can no longer attain ready for takeover as a result of the delay. There's GC 6.5.3.4 that deals with a situation where there's a delay beyond the contractor's control. They'll be entitled to extension of contract time anytime they're delayed due to a cause beyond their control. However, that clause does not entitle you to additional payment. However, there is another clause, GC 10.2.7, which basically states that if subsequent to the time of bid closing, changes are made to applicable laws, ordinances, rules, regulations, or codes of authorities having jurisdiction which affect the cost of the work, then the contractor in those circumstances would be entitled to change in the contract price. Now, there is another relief provision for inordinate delay, if you will, or stop work or situations. That's GC 7.2.2, but it's a rather harsh one. It's the one that allows the contractor, if the work is suspended or delayed for 20 working days or more by a court order or by an order by a public authority through no fault of the contractor or anyone in the contract responsible, gives the contractor the ability to terminate the contract if they so choose. However, that's a pretty blunt remedy to use in those circumstances. But interestingly enough, one of the supplementary condition changes that you'll see to CCDC-2 is either the removal of that particular provision or the extension of 20 working days, something like 30 or 35 or 40, given that most stop work orders that we've experienced due to COVID are 28 days or less. So that is wraps up my presentation. I'm ready to take questions. Hopefully you're all still with me. And I again apologize for the technical difficulty at the beginning. So Taylor, I think you're the one that's been watching the questions.
Yeah, so we do have a few questions here in the chat. So I'll just kind of read them out to you one by one. And then once you're done answering them, I'll read the next one. So the first question here, when new payment legislation comes into effect, will it apply to partially completed projects, or will they be grandfathered to allow them to complete under the previous terms?
That's a question for people putting your legislation into place. That obviously is not impacted by the contractor CCDC-2. What we did in Ontario is essentially we used when the projects were closing for bid. So if a project was already on the streets and already underway, the new legislation didn't apply to it. It only applied to projects that were out for bid, if you will, after the effective date.
All righty. So the next one we have here. On the holdback payment terms being payment due 10 days after expiry of the lien period, how does the GC protect their lien rights if we have to wait until the lien period expires?
It's a good question. And it comes up often. It is a bit of a game of chance. On the 29th day, if you will, now in Alberta, and you wonder, gee, has the owner got the money for the rest of the project? Are they gonna pay? Well, my understanding, and this is something the Alberta Builders Lien Act will address, not the contract. But my understanding is that in some provinces anyway, a finishing holdback is required even after the main holdback is released at substantial performance of work. Remember, at substantial performance of work, it might only be 97% or 98% of the actual contract completed. There may be another 3% to be done. My understanding in those circumstances is as legislation in some provinces, I'm not sure about Alberta, but I know in Ontario, for example, a further holdback, finishing holdback is required. So you could still lien based on those amounts not being paid. But by the 29th or 30th day, if you've still got amounts outstanding, your lien rights would still apply with respect to any new work being done under that project to finish the 2 or 3%. But that's a lien question. Really, it has nothing to do with CCDC-2.
Okay, awesome. Thank you very much. Next question. Can the 2020 version of the CCDC 41 be used with the 2008 version of the CCDC 2?
Yes, it could. There'd be nothing to stop that, although you have to be very clear in your front-end documents that was the case. In other words, the construction bidders, the specifications, whatever, would have to be very clear that these new insurance limits were in place for that project.
Perfect. Has the law determined that the CCDC 41 limits must be pushed down to subtrades?
That again is not a question with respect to CCDC. It's more a question of insurance or risk management. That's something to raise with your insurance broker or insurance provider, because depending on how your insurance is put together on a particular project, and even for your own business, will determine how you deal with potential overlapping or et cetera. Normally, the subcontractors are added as named insured on a lot of policies. So that's one way of dealing with this. But you're better off to ask your insurance broker or risk manager.
Okay, awesome. And as far as I can see, this is the last question we have here this morning. Do you know expected timeframes to update other CCDC contract types?
I know they're working on it right now. They have subcommittees that are working on changes to the other documents. My understanding is they've given some priority to the construction management documents, 5A and 5B. I guess they're basing it on usage. What are the contracting methods and the standard contract forms that are being used most often? So my understanding is they're giving some priority to construction management documents. So you should see that sometime, probably my best guess is towards the end of this year. Similarly, I've heard that they've got a subcommittee also looking at the design build documents, so 14 and 15. So you probably more importantly, and perhaps more quickly, you're going to see a new subcontract form coming out of the CCA, because obviously the changes to CCDC-2 could have an impact on subcontracts. So the CCA stipulated price subcontract form CCA1 is, I understand, is close to being finalized and could be out early summer, maybe late spring. Yeah, that's my understanding of the sort of time scale that they currently have.
All right. I don't see any more questions in the chat or in the Q&A. Oh, here's one last one here. Will the old version of the contract still be available for use? Or will the 2020 be the only valid CCDC-2 to be used?
My understanding is that, and I'm going on what they did the last time they introduced a new version back in 2008. They gave a bit of an overlap. They gave a year or so where they continued to produce or make available, if you will, the older version, so that there is some overlap between the two. So I would suspect that for at least a year anyway, and the new document was just introduced last December. So at least until the end of this year, I think you'll see that the old version will still be available. By the way, for any owners on the call or anyone that writes supplementary conditions to be used with CCDC-2, I would suggest that this is an opportune time, particularly with the new legislation coming in Alberta. It's an opportune time to review your supplementaries to make sure that they still jive with the new legislation, and that they take into consideration the changes that have been made to the contract. Too often, it's been my experience, supplementaries get written, added to, and nobody comes back and really does a thorough review to make sure that they even make sense, that they're not creating inconsistencies or conflicts, etc. So it gives you some time to hopefully, in that switch over, if you will, to the new document, review the standard supplementaries you're using.
Excellent. Yeah, I don't see any more questions. That seems to have been the last one. Just everyone is saying thank you to you here in our chat. It was a great presentation.
Well, that's great. Well, thank you very much for participating. If you do come up with any other questions or issues, comments, points, Taylor, you can always reach me through Taylor. So I'd be happy to hear them, happy to listen to them. And as time goes forward, how the new ready for takeover concept is going to be used. That's going to be interesting. And if you have any thoughts or comments about how the document could be better, that would be appreciated as well. So thank you very much.
Thank you guys very much. Have a wonderful day.